Let's get you on there.
I think this one's working.
There you go.
We had a letter that was discussed, I know, with Mr. Butler before lunch, I think, and it's the letter from Jake Moore addressed to Wallace Lightsey of the Weiss Law Firm, and this is the discussion of Ms. Walker and her inability to currently appear. And I was wondering if I could put this into the record as the next hearing exhibit.
Okay, we will enter the letter from Jake Moore into the record as hearing exhibit number 54. That's okay.
Good afternoon, Andrew Bateman with ORS, and I actually have a second housekeeping matter I wanted to attend to. This is a late filed exhibit. I believe Mr. James discussed yesterday a letter, and I believe it was Commissioner Urban wanted to be a late filed exhibit. So this is late filed exhibit 34, and Mr. Thompson has copies that he'll pass out. I've got one copy right here. If I could approach Miss Wheat and
Absolutely, thank you.
This exhibit consists of a cover letter and I believe 3 separate letters subsequent to that cover letter. Yes, copies for the commission, and we printed off a number of copies. Clearly we didn't print off copies for everyone in the room. And while Mr. Thompson is passing that out, I'll call ORS's next witness, Mr. Seaman Wynn, to the stand. Thank you, Ryder. I apologize for the confusion, but does everyone, are you getting the correct 3 letters? These were the letters that Mr. James mentioned yesterday in testimony, indicating that ORS had informed the commission about certain activities occurring at the VC summer site.
Okay, and all 3 of those are exhibit number 34.
Thank you.
As we marked it yesterday, right? Correct. And they're in the record. We're entering into the record.
Mr. Seaman Wynn, would you please state your name and occupation?
My name is Michael Seaman Wynn. I'm a Senior Regulatory Manager with the South Carolina Office of Regulatory Staff.
And are you the same Michael Seaman Wynn who pre-filed 16 pages of direct testimony and 4 exhibits in this case on September 24th, 2018?
Yes, I am.
And if I ask you the same questions today, would your answers remain the same?
No. Subsequent to the filing of my direct testimony on September 24th, 2018, SC&G provided additional information that altered the conclusions of ORS witness Collin. As a result, the calculations and conclusions I reached in my direct testimony and exhibits were altered. These updates are included in my surrebuttal testimony and exhibits.
Thank you, Mr. Seaman-Wynn. Mr. Chairman, ORS asks that Mr. Seaman-Wynn's direct testimony be entered into the record, subject to the noted changes as if given orally from the stand, and that Mr. Seaman-Wynn's Exhibits 1 through 4 be marked as a composite hearing exhibit and entered into the record as the next hearing exhibit.
Okay, Mr. Seaman-Wynn's pre-file direct testimony as corrected will be entered into the record as if given orally from the stand, and his Exhibits 1 through 4 will be entered as Exhibit number 55.
Thank you. And are you the same Michael Seaman-Wynn who pre-filed 6 pages of supplemental testimony and 2 supplemental exhibits in this case on October 19th, 2018?
Yes, I am.
If I asked you the same questions today, would your answers remain the same?
Yes, they would.
Mr. Chairman, ORS asks that Mr. Seaman-Wynn's supplemental testimony be entered into the record as if given orally from the stand, and that Mr. Seaman-Wynn's supplemental exhibits 1 and 2 be marked as a composite hearing exhibit and entered into the record as the next hearing exhibit.
Mr. Seaman-Wynn's supplemental testimony will be entered into the record as if given orally from the stand, and his exhibits will be entered as Exhibit number 56.
Thank you. And Mr. Seaman-Wynn, are you the same Michael Seaman-Wynn who pre-filed 3 pages of rebuttal testimony in docket numbers 2017-207E, 2017-305E, and 2017-370E on October 24th, 2018?
Yes, I am.
If I ask you the same questions today, would your answers remain the same?
Yes.
Mr. Chairman, ORS asks that Mr. Seaman-Wynn's rebuttal testimony be entered into the record as if given orally from the stand.
Mr. Seaman-Wynn's rebuttal testimony will be entered into the record as if given orally from the stand.
Thank you. And are you the same Michael Seaman-Wynn who pre-filed 8 pages of surrebuttal testimony and 3 exhibits in docket numbers 2017-207E, 2017-305E, and 2017-370E on October 29th, 2018?
Yes.
And if I asked you the same questions today, would your answers remain the same?
Yes, they would.
Mr. Chairman, ORS asks that Mr. Seaman-Wynn's direct testimony, Mr. Seaman-Wynn's surrebuttal testimony be entered into the record as if given orally from the stand, and that his exhibits be marked as a composite hearing exhibit and entered into the record as the next hearing exhibit.
Mr. Seaman-Wynn's surrebuttal testimony will be entered into the record as if given orally from the stand, and his exhibits will be entered into the record as surrebuttal exhibits as Exhibit number 57.
Thank you. And just to confirm, that's Exhibits 1 through 3. Is that correct?
Exhibits 1 through 3.
Thank you.
Yes, composite exhibit.
Thank you. Mr. Seaman-Wynn, did you prepare a summary of your pre-filed testimonies?
Yes, I have.
Would you please share your summary with the Commission? And, excuse me, just prior to that, Mr. Thompson has Mr. Seaman-Wynn's summaries as well. If it's okay with the Commission, Mr. Seaman-Wynn will go ahead and begin with this summary.
Good afternoon, Mr. Chairman and members of the Commission. My direct testimony addresses concerns certain areas of ORS's examination of the application of SCENG and Dominion. Specifically, I address an overview of SCENG's natural gas operations in South Carolina, ORS's recommendations regarding natural gas operations should the merger be approved, ORS's review of the application regarding rates and riders, ORS's recommendations regarding its base rate reduction, capital cost recovery rider, tax savings rider, and merger savings rider under the ORS Optimal Plan, ORS's recommendation regarding the applicant's proposed rate credit to customers, and a comparison of the 3 plans proposed by SCENG and Dominion to the optimal plan proposed by ORS and the impacts of each proposal on customers. SCENG and Dominion do not ascribe specific benefits to SCENG natural gas customers in the application. Should the merger be approved, Dominion would own, either directly or indirectly, both transmission pipeline and distribution pipelines serving over 368,000 natural gas customers in South Carolina, as well as SCE&G's entire portfolio of natural gas-fueled electric generation stations. As such, ORS recommends the Commission establish certain conditions to ensure natural gas customers receive safe and reliable service at reasonable prices, and that electric generation from the purchase and transportation of natural gas is achieved on the most economical terms. ORS opposes SCE&G's proposal to reduce the rates of all electric rate classes by a flat 3.5%. For each revised rates proceeding, ORS, SCE&G derive the revenue increases for each customer class based on the utility's South Carolina firm peak demand data from the prior year. ORS recommends that any reductions in revenue should be allocated using the same methodology. Under the ORS Optimal Plan, ORS is recommending a base rate reduction of approximately $445 million, a capital cost recovery rider to recover approximately $86.2 million in prudently incurred NND costs, a tax saving rider to reduce retail electric rates by approximately $98.7 million, and a merger savings rider to reduce electric rates by $35 million during the first year and $70 million during the second year. ORS does not support the one-time rate credit proposed by SCE&G and Dominion. As addressed by ORS witness Collin, this rate credit is funded primarily through the proceeds from the Toshiba guarantee. As part of the Optimal Plan, ORS recommends these proceeds be used to reduce the allowed NND abandonment costs, coverable through the capital cost recovery rider. My supplemental testimony provides an update on the joint application of SCANA and Dominion in North Carolina docket numbers E-22 sub 551 and G-5 sub 585 and ORS's supplemental recommendations based on the update. Specifically, I address an overview of the natural gas operations of PSNC in North Carolina, the stipulation agreement reached between the applicants, Transco, and the North Carolina public staff regarding the North Carolina application, and additional ORS recommendations to benefit SCE&G natural gas customers and provide additional protections for all electric and natural gas customers. Similar to SCE&G natural gas operations in South Carolina, PSNC is engaged in the purchase, sale, distribution, and transportation of natural gas to approximately 563,000 natural gas customers in North Carolina and would become a wholly owned subsidiary of Dominion should the merger be completed. On October 4, 2018, a stipulation agreement was reached between SCANA, Dominion, Transco, and the North Carolina public staff regarding the application in North Carolina. This stipulation provides PSNC customers with numerous benefits and protections should it be approved as part of the merger in North Carolina. After reviewing the North Carolina stipulation, ORS recommends that the Commission consider including a most favored nation clause in its final order. Additionally, ORS recommends that SCE&G provide a total bill credit of $2.45 million that will be credited to its natural gas customers over 3 years. These recommendations are to ensure that South Carolina SCANA customers receive the same benefits and protections as North Carolina SCANA customers. My surrebuttal testimony responds to rebuttal testimony of SCE&G witness Alan Brooks and Dominion witness Robert Blue regarding allocation methodology of the merger savings rider and the tax savings rider, most favored nation clause and importance to South Carolina ratepayers, bill credit of $2.45 million to SCE&G's natural gas customers in South Carolina, and incorporation of updates to the ORS optimal plan. In rebuttal testimony, SCE&G witness Rooks recommends the tax savings rider benefits be allocated on energy sales rather than contribution to peak demand. ORS does not agree. ORS does not disagree that savings could be allocated using either peak demand or energy sales. However, ORS utilized an allocation that provides the most benefits to those customers that have been most impacted by the BLRA. Regarding the most favored nation clause, Dominion Witness Blue states that the most favored nation clause provides protections for Dominion and PSNC customers in North Carolina. ORS maintains that South Carolina customers should receive the same treatment as customers in North Carolina and Georgia, and that a most favored nation clause should be included in the Commission's final order. Dominion Witness Blue also states that ORS's recommendations for conditions and benefits for SCE&G's natural gas operations are beyond the scope of this proceeding. This is inaccurate, as any merger between SCANA and Dominion will impact all electric and natural gas customers. By entering into a settlement agreement with Transco, SCE&G, and Dominion recognize that the merger will impact natural gas customers. ORS affirms its position that the proposed $2.45 million bill credit to natural gas customers is the best way to guarantee SCE&G natural gas customers receive benefits related to the merger. Under the ORS optimal plan, the monthly bill for the typical residential customer on rate 8 using 1,000 kilowatt hours will decrease by approximately $30.93 or 20.94% from $147.70 to $116.77 in the first year. In the second year, the optimal plan will reduce a residential customer's bill to approximately $114.57, a reduction of $33.13 or 22.43%. This concludes the summary of my direct, supplemental, and surrebuttal testimonies.
Thank you, Mr. Seaman-Wynn. Mr. Chairman, Mr. Seaman-Wynn is available for cross-examination questions and questions from the Commission.
Thank you. Okay, for cross, Mr. Kyle.
No questions, Mr. Chairman. Thank you.
Other parties, Mr. Knapp.
Chairman. Mr. Seaman-Wynn, good afternoon.
Good afternoon.
Probably be our last one up here today.
Make sure you get into that microphone
Sure.
good. You're kind of speaking softly.
I'm sorry, sir. Thank you. Okay, so I was up here earlier. Did you hear me when I was talking to Mr. Collin?
Yes, sir, I did.
Okay, so you know then kind of why I'm going to be asking you the same type of questions.
Yes, sir.
All right. Commissioner Williams made an excellent point. He said that in our last conversation that the ORS plan itself allows SC&G to recover some of the abandoned construction costs. But don't you agree that what is more important to the consumer are the rates that they're paying than whether SC&G is able to recover some of the construction costs?
It's my experience that customers are most concerned with the rates that they are paying.
Thank you. And that's what I really wanted just for a minute to go over that with your testimony. you, unless you've changed it in your sir rebuttal testimony, and I didn't catch that, you had indicated that your residential customers' rates would be reduced by 20.93% with the ORS optimal plan in the first year. Is that correct? Or did you change those numbers on me?
No, sir, I have not changed any numbers in my sir rebuttal testimony.
Thank you very much. And then the second year would be 22.42% rollback.
That sounds accurate, yes.
Okay, and those are, of course, all from earlier in 2018, pre the experimental rates.
Yes, sir. Those are based off of pre-abandonment rates.
Right. Thank you very much. So what I'm interested in is then what will happen to the consumer, to the ratepayer, depending on which of the 4 plans that are on the table right now, depending on what the commission rules. Right now, they have a 15% reduction in the rate on the experimental rates, correct?
Yes, sir.
Right. So take those 4 plans, the ORS optimal plan and the 3 plans that we have that have been proposed by SC&G and Dominion. And what happens on the day after the commission rules on each of those plans? What happens to the rates for those consumers? And you can start in whatever order you want.
I'm not sure that I have all of the information that you're requesting, Mr. Knapp. But if I could direct you to page 8 of my sir rebuttal testimony, I have a table there that shows that after the commission's order for the applicant's customer benefits plan, the typical residential bill would go to approximately $135.66. That's down from $147.70.
But I interrupt you for a second. And what would that average bill be today with the experimental rates?
With the experimental rates, I apologize. Experimental rates today, a typical bill is $125.34.
So it would be higher than the average bill today, residential.
Under the customer benefits plan, yes.
But you have not calculated a percent.
A percentage based off of the experimental rate?
Yes.
No, sir, I don't have that calculation. Under the ORS optimal plan, same customer's bill would be $116.77.
And can we do some quick math here? If the customer's already had a reduction of 15%, and you're saying that the ORS optimal plan in the first year would be at 20.93% pre-abandonment reduction, we're looking at somewhere around an extra 5+% reduced rate.
Yes, that sounds about right.
Thank you. The other 2 plans that are possibility from Dominion and SC&G?
I don't have those calculations with me, but I do believe that they are in a hearing exhibit.
Okay, but to your estimate, they would all require a higher percentage rollback than the experimental rate. In other words, the rate that would be reduced would not be as high as the 15% for the experimental rate.
Generally speaking, yes, sir.
Okay.
I believe so.
All right. Well, they're very, very good. That's it. Those are my questions. Thank you very much, sir. I appreciate it.
Sir.
Thank you. Other parties. Mr. Elliott.
Chairman, I'm Scott Elliott. I represent the South Carolina.
Let's get you mic'd up first, because nobody can hear you globally.
Which is probably a good thing, Mr. Chairman.
I'm glad you said that.
Yes, sir. Mr. Chairman, I'm Scott Elliott. I represent the South Carolina Energy Users Committee. Mr. Seaman Wynn, I just want to ask you a few questions, if I may. Mr. Erskine? I am showing you a chart in Mr. Collins' summary. Do you recognize that chart, Mr. Seaman Wynn?
Yes, sir, I do.
All right. And I just want you to help me to understand these numbers and by percentage. Like Mr. Knapp, I'd like to have those numbers if I can. So the first two numbers on the chart, the minus 445 and the plus 367.4, that basically, that is an accounting, I think, measure just to zero out the $445 million in revised rates. Is that correct?
Yes, that's correct.
All right. And do I understand correctly that that $445 million figure is constituted at one point prior to the emergency rate about 18% of the typical customer's E&G bill? Is that correct?
Prior to the experimental rates going into effect on April 1st, yes, sir.
All right. So, ORS is going to reduce the rates by taking out the revised rates, and that'll be an 18% reduction, say, from, you put it, from pre-abandonment rates, I think was the way you put it in your testimony, right?
Yes, sir.
All right, let's use that term. Now then, what ORS proposes to do is to add $85.9 million in annual revenues so that SCE&G can recover off the abandoned nuclear equipment up in Jenkinsville. Is that correct?
This is to recover the prudently incurred nuclear costs up until March 12th, 2015, yes.
Righto, thanks. Now, that would have the impact, by adding in $85.9 million, of increasing the customer's rates by about 3.5%. Isn't that correct?
I don't have the percentage with me, but that seems about right.
Seems about right to me, too. So you're going to raise rates on SC&G's customers to pay for those abandonment costs that you just described in your testimony, correct?
The capital cost recovery rider would raise rates so that the company could recover costs for those prudently incurred nuclear costs, yes.
Great, that's good, thank you. And then the only other figure I wanted you to draw your attention to is the $98.7 million figure, which I think is the tax reduction associated with the Tax Cut and Jobs Act of 2017. Is that correct?
Yes, sir, that's correct.
All right, and there are other tax ramifications, but in that particular matter, you're going to reduce rates by $98.7 million. And, you know, by my rough calculations, that's about another 4.5% rate reduction. Does that sound about right to you?
That sounds about right.
All right. We'll leave it to the mathematicians to figure all that out. But
well, I could have run those calculations. I simply don't have them with me today.
I understand. I didn't forewarn you. Now, I'd like next to turn to Mr. Collins' color chart here, summary comparison of NND and project cost recovery. Do you see that chart?
Yes, sir, I do.
It's on the screen here. And if you look at the, as I understand it, if you look at the blue line, it indicates that the company would recover under the ORS plan the $86 million over about 20 years. Do you read the chart that way?
Could you repeat the question?
All right, you see the blue line?
Yes, sir.
And you see the legend says the blue line is the blue line says ORS full return. Do you see that?
Yes, sir, I do.
And do you see in the margin, incrementally the values go up from 0 to 50 by million to 100 million to 150 million and so forth?
Yes, sir, I do.
And would you agree with me that the blue line is about $86 million?
Yes, sir, and that would correspond with what is the table that I saw previously.
All right, so that's the $86 million rate increase that the ORS proposes, correct?
In conjunction, as part of the optimal benefits plan, yes.
All right. You have a reason for it, but a rate increase is a rate increase, isn't it?
Well, it's part of an overall plan that includes significant rate decreases to customers.
All right. Now, if you look at that legend again, please, you see the gold is the Dominion merger, including the one-time refund. Do you see that legend beneath the graph?
Yes, sir, I see it.
And so the way Mr. Collins has done this is looking at the left. He starts out Dominion at about 0, and it goes almost vertically straight up to a point about $350 million. And according to Mr. Collins' testimony, that's how he represented that upfront $1,000 to everybody refund. Do you recall that?
I believe that was Mr. Collins' testimony.
All right, and then that line levels off, and I apologize, my eyes are not that good. That levels off a little over $300 million for about 10 years, 12 years, something like that. Is that how you read that legend?
I believe that is levelized for the first 8 years.
Okay. And then just above that is the green line that goes all the way out 50 years. And according to the legend, that's the SCE&G no merger number. Is that your understanding?
Yes, sir, it is.
All right. And so if the $86 million, as represented by the blue line here, is a 3.5% increase on ratepayers, by my calculations, the green line, the SC&G no merger calculation, is at about 13% rate increase. Would you come to the same conclusion, roughly? Take a moment. It looks like
significantly higher than the $86 million in the ORS plan.
Yeah, and it's about $325 million if I read Mr. Collins' chart correctly. So by my rough calculation, that's about a 13% rate increase. Would you agree, subject to checking your calculator?
Subject to check.
All right, and so whereas the ORS wants to raise rates on ratepayers by 3.5%, E&G would raise rates by approximately 13%, correct?
I wouldn't put it like that, Mr. Scott.
Well, why wouldn't you? Because if $86 million represented by the blue line is a 3.5% increase, and $325 million annually is about a 13%, is the equivalent of a 13% increase, why would you not agree that E&G wants to raise rates by 13%, at least initially, to recover what is now only euphemistically called the new nuclear development costs?
All of the plans proposed by the applicants and by ORS are all rate decreases from current rates, not including the experimental rates.
Well, that's the bottom line, but I'm simply asking you with respect to the recovery of these nuclear costs, the company's rates are going to go up, are they not?
Respect to the nuclear costs.
Nuclear cost recovery, they're going to raise rates on ratepayers to pay for those costs, are they not?
No, sir, they're not.
Okay, so it's just how are they going to get paid? How is the company going to recover those costs?
There's going to be a reduction from what they are currently charging customers.
Are the ratepayers going to pay a cost for the company to recover these nuclear costs or not?
Yes, sir, they are.
They are. Thank you very much. And in your scenario, the cost is 3.5% annually, correct?
It's about $86 million a year.
And under your rider, do you propose to this commission to add a line item to the E&G customer bill demonstrating to the ratepayer that they are paying 3.5%, the equivalent of 3.5% towards E&G to recover those costs?
ORS believes that the customer should know what they are paying for. Should the commission order that a line item be placed on the bill for the capital cost recovery rider, ORS would make sure that the company is in compliance with that commission order.
And so you're recommending then that the commission put that line item on the bill. Is that your testimony?
I believe I can say that, yes.
Good. Thank you very much. No further questions.
Thank you. Ms. Thompson?
I mean to jump in front of you.
We're still not on, I don't think.
Let me try that again.
There you go. That's
Good
better.
afternoon, Mr. Seaman Wynn. I'm Gudrun Thompson, representing the South Carolina Coastal Conservation League
Good afternoon.
and Southern Alliance for Clean Energy. Were you here yesterday when my colleague, Mr. Cleveland, was asking Mr. Collins some questions?
Yes, ma'am, I was.
Now, Mr. Collins was understandably not familiar with some of this commission's procedures, so I'd like to follow up with you on that. SCNG enters into contracts for capacity on natural gas pipelines, correct?
Yes, ma'am, it does.
And SCNG recovers the costs incurred pursuant to those contracts in the annual fuel clause adjustment proceedings, isn't that right?
Regarding electric rates, yes, it is also reviewed during the purchase gas agreement reviews for natural gas customers on an annual basis.
And in those two kinds of annual proceedings, ORS looks at the costs incurred pursuant to those contracts and makes a recommendation to this commission whether to allow or disallow recovery of those costs, correct?
We make those recommendations to the commission, who is the deciding act.
But that review, ORS's review and this commission's review, does not occur until after the contract has been signed and the costs have been incurred, correct?
The calculation of the costs, yes, ma'am, I would say that's correct.
Now, in your testimony, or ORS recommends a merger condition related to contracts for gas supply transportation. Is that right?
Yes, ma'am.
Okay, and I will just read it to you, and you can correct me if I get anything wrong, but just let me know if this is generally correct. SCNG should be required by the Commission to engage in good faith negotiations with third-party suppliers of gas and transportation capacity, and affiliated transactions should be scrutinized. Does that sound right?
I'm not sure if scrutinized is the correct word.
I believe, if I have the citation right, I believe it's on page 5, lines 4 through 9 of your testimony, that might be a reference to an exhibit.
My direct testimony?
I believe so. And if that's wrong, then it's probably in your rebuttal.
What were those line numbers again?
Page 5, lines 4 through 9.
I apologize. Scrutinized is the correct word.
And the rest of that proposed condition says SCNG should be required to follow a least cost standard with regard to contracting for gas supply, transportation, and storage services to ensure fair pricing among service providers and that business decisions are not biased in favor of affiliate transactions.
Yes, ma'am.
Okay, so again, ORS is recommending that this commission scrutinize affiliated transactions, right? As part of, I'm sort of paraphrasing the proposed condition.
Yes, ma'am.
Are you aware that Dominion is an owner of Atlantic Coast Pipeline, LLC?
I understand that they are.
Would a contract signed by SCNG for capacity on the Atlantic Coast Pipeline qualify as the kind of affiliate transaction that you describe in your testimony?
To my knowledge, the Atlantic Coast Pipeline is not in the boundaries of the state of South Carolina, as SCENG is a South Carolina utility. I don't see it entering into a contract with a pipeline that ends north of the border.
That's a good point. Let me back up a little bit, and then I think I'll ask you to entertain a hypothetical. So, post-merger, if the merger closes, SCE&G would be an affiliate of, or be a subsidiary of Dominion, correct?
Correct.
Okay, and I'm going to ask you to just go with me on a hypothetical. If the Atlantic Coast Pipeline were to be extended into South Carolina, and SC&G were to sign a contract for capacity on the Atlantic Coast Pipeline, then in that case, the contract would be an affiliate transaction, correct?
I would consider it an affiliate transaction, yes.
Okay, and when SC&G signs a contract with for gas transportation company, capacity with an affiliated company, does SC&G currently need approval from the commission to enter into that contract?
SC&G does not need approval from the commission to enter into any natural gas transportation contract.
Okay, thank you. That's all the questions I have. Thank you, Mr. Chairman.
Thank you, ma'am. Other cross. Reed.
Mr. Chairman, Joe Reed on behalf of Dominion Energy. Good afternoon, Mr. Seaman Wynn.
Good afternoon.
I'm putting up on the screen here second page of what's been marked for identification in this case as Exhibit 52. Do you see that, sir?
Yes, sir, I do.
And were you present in the courtroom earlier today when I asked Mr. Collins some questions about this particular exhibit?
Yes, I was.
Did we have the opportunity to confer during the break about some of the numbers that are depicted on this exhibit?
Yes, we did.
All right, sir. So Mr. Collins was unable to verify some of these numbers on the exhibit because he was dealing with a revenue requirement and not a bill amount or an incremental bill amount. Let me ask you, sir, can you verify these numbers in the first bar of 147.53 for the total bill and 25.10 for the N&D increment?
Typical residential bill for rate 8 customer, 1,000 kilowatt hours, at May of 2017 was $147.53. Yes.
And can you likewise verify the 140.40 in the second bar?
That seems accurate.
And the third bar, 136.07?
Yes, that seems accurate.
And the Plan A bar, 135.64?
That is very close to what I have in my testimony. I may be off by a couple of cents. I believe that may be due to rounding, but for purposes of agreement, yes.
And the Plan B number, is the 126.96 the number that was presented in Mr. Pruitt's supplemental rebuttal testimony?
That is a number that was presented in his testimony.
And the 125.34 that we see for the temporary rate, can you verify that that's accurate?
Yes, sir, that is accurate.
And of course, we've already talked about the 116.77 being the number for the ORS optimal plan in year one, right, sir?
Yes, sir.
Okay. And one other question here. Mr. Elliott asked you some questions about the incremental increases in the bill that could result from the Commission's decision in this case. Do you agree with me mathematically, Mr. Seaman Wynn, that the difference between 453 as shown here on the screen for the Dominion Plan B N&D increment and the 291 N&D increment under the temporary rate is about $1.62, the difference between 453 and 281?
Mathematically, I would agree that is the difference between those two numbers. However, I don't believe that the $2.91 under the experimental rate for N&D costs is correct.
You don't believe that number is correct?
No, sir, I do not.
Okay. What do you think that number is? We want to get it right.
The experimental rates, reduced rates for docket number 2011-207E going forward. So the increases that were authorized by the Commission in docket numbers 2008-196E, 2009-221E, 2010-157E would still be in effect. For those three increases, my calculation is $4.66.
Okay. All right. So that's good information. So if the total incremental rate that is in effect now is $4.66, would it be correct then that if this commission were to adopt Plan B, that the bill would actually go down by 13 cents?
Having a little trouble reading the number in the blue block. Difference between $4.66 and $4.53 is 13 cents. Yes.
All right, sir. Thank you. Mr. Chairman, since there's still maybe a little bit of discussion to be had about these numbers, I will reserve asking for the admission of this exhibit. And that's all the questions that I have. Thank you, Mr. Seaman Wynn.
Thank you.
Mr. Chairman, that elicited just a few questions I need to ask. Thank you, Mr. Seaman Wynn. I'm Michael Anselmo. I represent the Speaker of the House. Just a second ago, you were going through with Mr. Reed the percent or the dollar figure that was still remaining after the experimental rate went into effect.
Yes, sir.
You testified it was $4.66, and that resulted from 3 prior revised rate orders remaining in effect, correct?
Yes, sir, that's correct.
Did that $4.66 include any cost for transmission?
I'm not sure. That includes all costs for those 3 revised rates proceedings.
Subject to verification, would you be willing to agree with me on this statement that the revised rate orders include portions about $2 for transmission costs in each one of those revised rate increases?
In each one of the revised rates proceedings?
For the 3 remaining, I'm sorry, the 3 that you mentioned when you were talking to Mr. Reed.
Let me understand. You're saying that of the first 3 revised rates proceedings, transmission costs were $2 of the $4.66 on a residential bill?
Let me rephrase that. Question was cumbersome. My question is, did the revised rate orders also include a component for transmission costs?
Lead transmission costs were included in all of the revised rates proceedings.
Do you recall the amount of the transmission costs that were included?
No, sir, I do not.
Would you accept if that, subject to verification, that number was about $2 per bill?
Is that going through the most recent revised rates proceeding?
Excluding, yes. Yes.
Subject to check, yes.
The reason I'm going there is that the chart that Mr. Reed was using at the top says excluding transmission. Do you see that at the top in the gray highlighted portion?
Yes, sir, I do.
And the reason I think that's notable is that when the House was calculating the experimental rate, our rate included the $2 transmission cost. Are you aware of that?
I believe so, yes, sir.
So if you included the $2 transmission cost to what would be the optimal plan under Plan B, that $4.53 would actually be $6.53, correct?
If you were to add $2 to the $4.53, yes, it would be.
Okay. So if you included $2 to the Plan B and made it $6.53, and you included the $2 in transmission to the experimental rate would still remain lower than the Plan B, correct?
If we were to say that the transmission aspect for the typical bill would be $2, then it would be a $2 difference across the entire charge.
So it's not actually, if you adopted Plan B, that it'd be 13 cents or whatever that number was that you discussed with Mr. Reed, less than the experimental rate, because the Plan B does not, as you just testified, include the transmission costs, correct?
I think that's a fair statement.
No further questions.
Thank you. Any other? Commissioners? Commissioner Elam.
Good afternoon.
Good
Mr.
afternoon.
Singleton. Under the optimal plan, ORS is allowing construction work in progress up to March 12th, 2015. Is that correct?
All prudently incurred costs through that date.
Okay. And it's also removing all revised rates, correct?
Yes, sir.
Why is ORS disallowing AFUDC on the allowed NND costs?
I'm afraid that question will be better answered by Mr. Collin.
Okay, thank you.
Commissioners? Commissioner Whitfield.
Thank you, Mr. Chairman. Good afternoon, Mr. Seaman Wynn.
Good afternoon.
Mr. Seaman Wynn, I got a few questions related or concerning securitization. Assuming that enabling legislation is passed and that the company makes use of that mechanism, how would securitizing the company's NND abandonment costs affect the company's title to the abandonment NND assets? In other words, if the title were transferred to the special purpose entity or special purpose vehicle that would be created under securitization, would it be possible for the company to reacquire the abandoned assets in the future?
Mr. Commissioner, I'm afraid I'm not in position to answer questions on securitization that was not part of my review in this case and would best be answered by witness Collin.
And I have let him get off the stand. I had a few other questions related to that, and just hypotheticals. If the company were able to take title back to it, or if another company came in and bought Santee, and were to purchase, who would have ownership? Or I guess you're also not in position to answer that either.
No, sir, I am not.
Let me kind of put it another way. Let me ask it another way, not about securitization. Let's ask another ownership question then. SCNG has clearly pursued the path of abandonment in the eyes of the IRS for federal tax credit purposes, correct?
That is my understanding, yes, sir.
And they made that decision a long time ago. So they're basically walking away from these two abandoned assets that haven't ever produced an electron, may never ever produce one. What ownership, in your opinion or ORS's opinion, and if you can't answer, just tell me, does Santee Cooper, or what interest, again, with us having no regulatory authority over Santee Cooper, what interest or ownership, in your opinion, does Santee Cooper have of the abandoned asset? Since they're not eligible for any federal tax credits because they're state-owned and not-for-profit, in your opinion, who owns them?
Mr. Commissioner, you're well outside of my lane. I'm afraid I cannot answer that question.
Okay. Well, let's move on to question that Mr. Anselmo was just asking you when he was crossing you just now about transmission. And he asked you about costs of transmission. He asked you about the cost to do with the rates. Those, as you well know, the commission had several siting hearings. We have siting authority here for the 230 kV lines and other transmission assets such as substations and other assets associated with those new transmission lines. And obviously, they're completed, they're used and useful, they're in service, but they're not, of course, transporting any electrons from the units that are abandoned. What is ORS's opinion, since you're the electric specialist, on the benefit? We know it provided hardening, and we know it provided high voltage transmission to some areas of the state that previously didn't have it. But what is ORS's position on the value of those assets, since they are used and useful, but the purpose that they were built, they're not being utilized for that, I guess is what I'm asking you.
It's a very roundabout question, Mr. Commissioner. Let me first say, yes, I'm very familiar with the transmission assets. I was the ORS witness in the siting for
Correct.
Both of the siting projects associated with the new nuclear units. As this commission knows, not all of those assets are yet used and useful. They are not all in service yet. The company filed a letter with the commission within the last couple of months stating that one of the transmission lines was not finished yet and was delayed until, I want to say, first quarter of 2019. That being aside, I believe that...
You're talking about the St. George line, is that correct?
That sounds correct, yes, sir.
Mm-hmm.
That being set aside, I believe that in the ORS optimal plan, and we're right on the edge of my lane on this, Mr. Commissioner, that ORS is recommending that we exclude the transmission in this case, put those into a deferred account and address them in a future general rate proceeding.
Future proceeding. That's your answer?
Yes, sir.
All right. Thank you. That's all I have, Mr. Chairman.
Thank you. Commissioner Hamilton.
Thank you, Mr. Chairman. Mr. Seaman Wynn, are you aware of any efforts by ORS to see that General Assembly has a securitization bill in next session? I know about approximately half the states do have this bill to use this tool, and it could be very helpful, as you've heard Mr. Cohen's.
If your question is ORS making recommendations to the General Assembly?
Do you know of any efforts?
No, sir.
Thank you, Mr. Seaman Wynn.
Sir.
Thank you. Commissioners, any other questions?
Mr.
Williams.
Mr. Seaman Wynn, in your testimony, you go on about the impact of each proposed plan to customers' bills, their monthly energy bills. Is that correct?
Yes, Commissioner.
Could you just sort of flesh out a little bit for me why you believe that ORS's optimal plan is the best for the customer when related to their monthly bill?
I would echo the thoughts of Witness Collin that the ORS plan provides just and reasonable rates. It balances consumer issues, consumer bills, with providing an opportunity for the company to obtain the money for its prudently incurred costs. I think it's a good balance.
What do you think Dominion needs to do if they wanted this thing to go through by way of a proposal from them? What do you recommend they do to their proposal in order to come closer to the balance that you believe the optimal plan provides?
Dominion and SCNG have provided a customer benefits plan in the original application. They provided an alternate customer benefits plan in the rebuttal supplemental testimony of some of their exhibits. The ORS plan is my recommendation for this commission, but we can see that Dominion and SCNG are looking to close the merger. They are looking for the opportunity to merge the two companies, to provide benefits to SCNG electric ratepayers. But it is my opinion that the ORS plan is the best plan for the ratepayers of South Carolina.
I understand that, and I appreciate your candor with your opinion. Is there any flexibility in that? Is it an all or nothing type deal? Is it what you have listed in your testimony with the optimal benefits plan, and that's the best plan no matter what? Or is there any type of flexibility in that?
Mr. Commissioner, that is up to the commission. You are the ultimate rulemaking body in this. As to whether there's flexibility, it is the purview of the commission to make a decision.
No, I get that part. I'm just asking your opinion. Do you think there's any flexibility based on what you know and what you testified to about the rates, the riders, the taxes? I mean, this is a very complicated issue. Wouldn't you agree?
Yes, sir, it is.
And I would suggest that you and every member of ORS and every party involved in this have given their best effort to try to present a reasonable solution. Is that a fair statement?
Yes, sir.
But reasonable minds can differ. Wouldn't you agree with that?
There can be varying opinions. We can see that from all the testimony in this case.
And so my question to you is there any flexibility on the optimal plan that could still reach the balance for ratepayers and the company?
I believe that there is always room for movement, but this is the plan that we have presented to the commission. The applicants have provided multiple alternate plans. It is up to the commission to decide what is the appropriate way to proceed.
Thank you, sir.
Yes, sir.
Commissioners, anything else? Mr. Bateman, any redirect?
One point of clarification, I think that can be done by.
Good answer.
Mr. Seaman-Wynn, you discussed a typical bill. Does a typical bill, a typical residential bill, is that 1,000 kilowatt hours a month, I think on a residential rate 8, is that correct?
That is what ORS and this commission have used for the last, since I have been with ORS. It's 1,000 kilowatt hours, yes.
That was the one point of clarification I had with Mr. Seaman-Wynn. Mr. Chairman, I appreciate your indulgence. ORS has no further redirect for Mr. Seaman-Wynn, but would like to reserve the right to bring other pre-filed witnesses up later in the proceeding should that ability arise.
Thank you.
Mr. Chairman, may I be heard on one witness issue?
Certainly.
Again, James Cox from the Weich Law Firm in Greenville, appearing on behalf of the ORS. The ORS filed a letter with the Commission yesterday regarding the availability of the two pre-filed witnesses left on the ORS's witness list, former SCANA Vice President Carlette Walker and former SCE&G Senior Engineer Kenneth Brown. We've received an update at approximately 4 p.m. today from Ms. Walker's attorney, and Ms. Walker's attorney has informed us that Ms. Walker is available and willing to testify this Friday between 1:30 and 5 p.m. And for that reason, the ORS would request a date and time certain for her testimony at that time. Mr. Chairman, Ms. Walker did have one special accommodation request in connection with her testimony, and it's the request that was included in the letter that the ORS provided to the Commission regarding the testimony that Ms. Walker gave during her deposition. And Ms. Walker has maintained her request that the four senior executives of SCANA at the time that she was employed by SCANA, Mr. Marsh, Mr. Byrne, Mr. Addison, and Mr. Archie, not be present in the hearing room during her testimony. And so for that reason, Mr. Chairman, the ORS would make that request. I think the record kind of indicated the reason that Ms. Walker was making that request, the traumatic nature of her experience and the end of her employment with SCANA.
Okay, we'll hear from SCE&G on that.
Mr. Chairman, that's an extraordinary request, and I'd like to have permission to confer with my clients perhaps overnight and respond in the morning.
That's fine.
One point of clarification, if I could, is I understood the Commission's ruling with respect to Ms. Walker and Mr. Brown's testimony pursuant to the request that ORS made just before the hearing. It's understood that they were going to essentially have those two witnesses adopt their deposition testimony taken by the ORS in the same manner as pre-file testimony would be, and then submit those witnesses to cross. And I just want to confirm that that is indeed going to be the procedure that's used.
Mr. Chairman, we would like the opportunity for Ms. Walker to be able to, as with other pre-filed witnesses, to read a summary of her pre-filed testimony into the record.
And she'd be subject to cross.
Of course, Mr. Chairman.
We have no objection to that.
Okay, so you'll get back to us in the morning on your thoughts on the absence of the executives, and then we'll talk about the time certain. Okay, the time certain's fine. We'll do that. Okay, we'll wait to hear from you.
One other point I would make, if I could, it sounds like Ms. Walker has provided a time limit for herself as to which she would appear. And as I understand the order of witnesses, the order of parties being able to cross, I want to make sure that we, as the party to whom that testimony really is directed, have ample time to cross-examine her. So the friendly cross, I think, we would want to be severely limited.
Okay. Talking with Mr. Butler, we will do our best to meet those times, so she may have to, we've got to get through the cross. So we'll make sure we get to that. So, yeah, everybody has to have an opportunity to be able to, so.
Thank you, Mr. Chairman, and we'll speak further with Ms. Walker's attorney about
Okay.
this. Of course, this is new information to us too, as well.
Understood. Yeah, and just come back to us in the morning, Will, once you've talked about that.
And one other
Yes, sir.
point, Mr. Chairman, as I understand it, a date certain of Friday has been set for witnesses Hebert and Lapson. They were in the morning, so we would need to, of course, the parties would need to have ample time to cross-examine those two witnesses, and that may or may not be finished by the time set by Ms. Walker for her to appear.
Okay, I mean, we're trying to get everybody in here. We're going to do the best we can. Okay, all right. Gotcha. Thank you. We do have the opportunity to recross on Mr. Seaman Wynn on the one question that he got asked. Okay. Mr. Seaman Wynn, you may step down. Yes, sir.
Thank you, sir.
Is Mr. Seaman Wynn excused, Mr. Chairman?
Sure. We may have to bring him back. I don't know. Well, not right now. We're going home right now. We'll excuse you for today. Okay. All right. Want to remind everyone that tomorrow morning at 9 a.m. we're going to have a PGA hearing. So this hearing will resume hopefully at 10 o'clock. And if there's nothing else, we are adjourned.